Well, I just don't understand. I mean, I'd like to go for 50-50 legal. And then when I did that, Monica took my time away because I had him every weekend for 8 years.
The parties come in and they can't quite get the parenting time situation squared up. So I say let's have the front of the court do it. And that's still not to your liking, Mr. Wheeler?
No, I just mean, well, I figure it's, what is it, 4 days a month based on what they got right now every other weekend. I mean, she gets every week as it is. I'd like some weekends or something. I mean, I know my car is out right now, so I'm kind of dealing with that. But I can get rides and stuff like that to get him taken care of.
Do you think that you have evidence to present at an evidentiary hearing that would sway the recommendation into your favor?
Well, I just don't understand. I mean, I'd like to go for the whole thing for starting this thing was to go for 50-50 legal, which is what my original goal was. And then when I did that, Monica took my time away because I had him every weekend for 8 years.
Yeah, I know.
The question is I read your objection and I just want you to understand something is you can keep objecting. I don't have any problem with that, but at some point in time, I think you have to realize that you're not going to get everything you want.
Well, I understand that, but this is my first time objecting, and I mean, a father needs more time with his son.
Right, but now, this from here to 4 is going to get very complicated for you, for both of you, because I'm going to have my clerk schedule an evidentiary hearing, and it's like a trial. Okay. And at this trial, you need to bring in evidence. You need to present evidence. You need to have it admitted into evidence. You need to prepare before the evidentiary hearing witness lists, exhibit lists. You need to exchange exhibits. You need to file a brief outlining the issues. So it's very complicated. Okay.
Just for visitation time? I mean, that doesn't make sense.
Yeah.
Why would a father? Why can't a father have 50-50?
I can't answer that for you because I don't know anything about the recommendation. I don't get that recommendation until closer to the evidentiary hearing. So the parties are free to negotiate something on their own, and then if it's in the best interest of your child, I would probably sign on to that. But this is what the objection does. The only where to go from here is an evidentiary hearing. So if the parties want to get together before the evidentiary hearing and try and hammer out a solution that might not be everything you want, but you can certainly live with it, I don't have a problem with that. But otherwise, we have to have a trial on your objections, and that's the next step from here. Okay.
It's kind of crazy to me, but I mean, I guess.
Well, the law is very complicated, David.
It is. I know. Yeah.
And if either one of you were thinking of getting an attorney, now would be probably the time to do it. But I'll set that up for you. My clerk will send out the notice, and you'll get notice of when that is. And if we don't hear from you, then I'll plan to conduct the hearing and make a decision after I've heard the evidence. Okay?
Okay.
All right. You're all set. You have a great anything in your motion you want to tell me before I hear from Mr. Cam? No, I would just say that I filed a motion because there is currently no parenting time required.
It's something that we've agreed upon through mediation through the judgment of divorce. Paragraph 11 says that we will be doing this reasonably and mutually agreed upon by the parents, and I don't believe that's been fulfilled. I don't believe it's mutually agreed upon by the two of us at this time.
Well, it's somewhat vague, right? I mean,
Correct.
if the court order that is that parenting time will be as the parties agree,
Mhm.
then if the parties don't agree, there is no parenting time, right?
That is correct.
Okay. Mr. Cam, what can you shed on this? I read your response.
What can I what?
You want to shed any light on this for me?
Um, sure. We have originally, when we went through mediation, there was quite a lot of conversations, a lot of agreements that he has not held up to. I originally was planning on him having the kids one evening a week, unless they had other activities or things going on where that wasn't possible. I'm not very comfortable with him having the kids in his car just because of his history with alcohol abuse and getting multiple DUIs and telling me that he doesn't believe he has a drinking issue. So I feel it's a safety matter.
Well, let me ask you this. According to your response, at least it looks like to me anyway, that most of those issues occurred long before you and him signed a an October 30th, 2024 stipulation. Is that true?
I believe his last DUI he was still under probation at that time.
Okay.
Or maybe he had just ended probation.
Well, see, my point is this. I can consider changes of circumstance since the last order. And the last order is clearly October 30th of 2024. And anything that occurred before that, it's not irrelevant. I don't want to say that because obviously, if it's an ongoing situation, that can be problematic. But it looks like to me is the parties just can't seem to get out of the starting gates on this stuff. And I certainly can't decide that on a Friday morning. But I will tell you that pursuant to Shade versus Wright, 291 Michigan Appeal 17, a 2010 case, I have to have at least proper cause or change of circumstance to stick my nose into your parenting time business because most people don't want courts involved in their lives. But poor communication or lack of cooperation between parents does constitute a change of circumstance to revisit parenting time because the relevant best interest factor, MCL 722.23.
J is in and Jimmy diminishes each parent's ability to encourage a close and continuing parent-child relationship between the other parent and the child. Those was set forth in an unpublished decision of Bowman versus Hartman, which obviously is not binding for stare decisis purposes on me but is persuasive.
So my only recourse at this point is to reopen parenting time, send it to the front of the court for a complete investigation and a recommendation. Mr. DeCam, are you currently working?
Yes, I am.
And Mr. Cam, are you currently working?
Yes, I am.
Okay. So the fee for that investigation and recommendation is $300. It'll be split between the parties. What they will do is they'll meet with both of you before they do anything, and it'll be by Zoom. And they'll see if they can't come up with an agreement that you both can live with, I guess. And if you can't, then they will conduct a full-blown investigation. Both parties have to fill out questionnaires. They will talk to whomever witnesses you wish them to talk to. They may talk to the children, they may not. And at the end of the day, they will make a recommendation to me about what parenting time should be, and the parties can accept it. And if that's the case, an order would be entered and it would be done. Or they can reject it, and in which case I would have to, like my last one, have a evidentiary hearing, a trial on what I believe parenting time should be. So that's kind of where we're at this point in time. I'll get the ball rolling for you guys. But I really hope that when the friend of the court meets with both of you, which usually is in a couple of weeks, that they can come up with an agreement and put an end to this thing. But if not, we'll run a complete investigation. Okay? That's what
Perfect.
I can do for you. All right?
Thank you, Your Honor.
All right. Thank you both. And make sure the friend of the court has your current addresses and all that. If there's any doubt in your mind, go over there to 82 Ionia and make sure they have it, because they don't forward mail. And I don't want anybody getting lost in the problem. Okay.
Thank you, Your Honor.
Good luck, both of you.
Thank you.
Next.